2017 Zoning and Land Regulation Committee. The first item on the agenda is public comment on any matter not listed on the agenda. Is there anyone here wishing to speak on an item not on the agenda? Seeing none, I'll move on. Before we start with the actual work of the meeting, I would like to make introductions of the committee members and the staff, and then I will give a brief overview of the rules of the committee. We have with us this evening Supervisors Jerry Bullig, Patrick Miles, and El Matano. Also with us this evening is Zoning Administrator Roger Lane and Assistant Zoning Administrator Dan Everson. Also, we have Director of Planning and Development Todd Violante and Planner Kurt Kogel. Also joining us tonight are our youth governance members, Joe Finkelmeyer and Garrett Stolen. This is a public hearing meeting. The committee will be conducting a public hearing on zoning petitions and conditional use permit applications. Any persons wishing to speak in favor or in opposition must fill out a white registration form. And the forms are over there where you see the gentleman filling them out now. Again, to be able to speak, you need to fill out one of those forms, and you can turn them into the staff. When a petition is called, the petitioner will be asked to come to these two chairs, one of these two chairs here. We ask that the petitioner state their name, address, the petition request, and the reasons for the request. The petitioner will be given up to 5 minutes to address the committee. The order of the registrants is as follows. After the petitioner or agent or any person wishing to speak in favor, then persons wishing to speak in opposition. All speakers will be given 5 minutes to speak. If there is opposition, the petitioner or agent will be given an opportunity at the end of the public hearing to provide a rebuttal to the opposition. The petitioner will be given an additional 3 minutes. All speakers will address the committee. These are the committee members right here, and not individuals in the audience. There will be no running debate. The committee will not take action on a petition until the applicable town has filed a report with the zoning division. The deadline for the town to submit an action report to the county is the Thursday prior to the meeting date. Public testimony will be taken at this meeting, however. If town action has not been received, a decision will be made at a subsequent meeting. If there is public opposition on a petition, the petition will be postponed until the next meeting of the committee. This will give the petitioner, opposition, and staff an opportunity to work out matters between parties. If the town's action has been submitted and there is no opposition to a petition, the committee may act on the petition and refer the petition to the county board. If the committee passes the petition unanimously, the petitioner's presence at the county board may not be necessary. However, if the petition is controversial, it is advised to attend the county board meeting. Committee action on a conditional use permit is the final action of the county. These applications are not referred to the full county board. The next county board meeting is February 9th. That of these petitions will be decided at. The next CLR committee meeting is February 14th. Okay, our first petition is a rezone 11,075 Nathan Paoli in the town of Medina. Please.
Maybe to sit or stand.
You sit, please.
My name is Nathan Paoli, 815 Clarkson Road, town of Medina. Currently looking to rezone current RH2 to A2 to start a limited family business. Looking to get a retail dealer's license.
Anything else?
No.
All right, thank you. Anyone else wishing to speak in support? Anyone wishing to speak in opposition? None. Roger?
The town of Medina has approved both the zoning petition as well as the conditional use permit. The zoning petition was approved with no conditions, and there were 3 conditions as part of the approval of the conditional use permit. Staff is suggesting an additional 5 conditions, and they're noted in your packet.
I'll move approval of the rezone.
Second.
Okay, any further discussion on the rezone? Seeing none, all those in favor say aye.
Aye.
And it is. The rezone is passed, and next is the CUP 2368.
Yes, I'm just wondering, are you in agreement with all the conditions on the CUP?
Yes, I am.
Even the 5 additional ones that were added?
Yes.
Okay. I'll move approval of the CUP with the town and staff conditions.
Second.
Any further discussion on CUP 2368? Seeing none, all those in favor say aye.
Aye.
And the CUP is also approved. Okay, thank you.
Thank you for your time.
Okay, next is petition 11,076, Emily Stolitsky in the town of York.
Good evening. My name is Mark Tomaszek. I'm the land surveyor for Emily. She has land at 7555 State Highway 89, Section 11, Town of York. She's requesting a change from A1 exclusive to A24. The reason for is for separating the residents from the farmland. The town has asked that it be rezoned to RH2 rather than A24.
Okay, anything else?
That's it.
Okay, thank you. Anyone else wishing to speak in support? Anyone wishing to speak in opposition? Seeing none, Roger?
The town of York has approved this petition, conditioned upon the zoning district being changed to RH2. The surveyor has also located the septic system for the property and is going to be within the boundaries of the proposed CSM.
Move approval with the condition that it's rezoned RH2 rather than A2. Second.
Okay, we have a motion to approve. Any further discussion? Seeing none, all those in favor say aye.
Aye.
And the rezone is approved.
Thank you very much.
You're welcome. Okay, next is rezone 11,077, Scott Brickle in the town of Roxbury.
My name's Scott Brickle, 8637 Mac Road, Township of Roxbury, and we have .45 acres that we'd like to go change from A1 to RH1, just to add on to our residential lot.
Anything else? Thank you. Anyone else wishing to speak in support? Anyone wishing to speak in opposition? Roger?
The town of Roxbury has approved this petition with no conditions. There is also an email from Mr. Tierney, the neighbor that was in support of this rezone.
Move approval. Second.
Okay, we have a motion and a second to approve. Any further discussion? Seeing none, all those in favor say aye.
Aye.
And it's approved. Thank you.
Thank you very much.
Next is rezone 11,079, Mary F. Norland in the town of Pleasant Springs.
Michael Rumpf appears on her behalf. My address is 152 West Main Street, Cambridge, Wisconsin. This is a rezone from Ag 1 to RH3. And I've been working with zoning administrator for some other additional conditions. And that's what we're here for this evening. A1 to RH3.
Thank you. Anyone else wishing to speak in support? Anyone wishing to speak in opposition? Roger?
This petition was postponed at the town of Pleasant Springs. It will be on the March work meeting agenda.
I'll move postponement due to no town action.
I'll second, but I have a quick question.
Yes.
So Roger, it looked pretty straightforward. What was the issue at the town?
Well, I didn't appear at the last town board meeting by mistake.
Yes,
So their plan commission had approved it, and I missed the meeting. So 100% my fault. But all the conditions that I've been working with the administrator are met or will be met in due
Thought I was
course.
missing something.
the proposed violation will be corrected. Mr. Dumpke, the person that has the building that is on the other person's property, is working with Mr. Rumpf, and the lot lines will be changed.
Next time.
Yes.
Not necessarily related to this, but it used to be the practice of the town of Pleasant Springs to not take action on a petition until after one through our public hearing. Are they still doing that?
They have changed their policies.
Okay. Thanks.
So, you know what? Okay. So we have a motion and a second to postpone due to lack of town action. Any further discussion? Seeing none, all those in favor say aye.
Aye.
And it's postponed.
We'll see you again.
Rezone 11,080, James Olas. And I don't have a form. Roger. The person.
I don't believe anybody's here to represent that.
Move to table.
Second. Okay, we have a motion to table due to lacking petitioner. All those in favor say aye.
Aye.
And rezone 11,080 is postponed. 11,081, Terry McCarthy. And Town of Deerfield.
My name is Jim Lowry. I'm acting as agent for Terry McConkey, Town of Deerfield. Terry would like to separate the existing farm buildings with 2.2 acres or thereabouts. And he would also like to create a 1.2 acre new home site just to the west of that. We understand that there would be a deed notice or a deed restriction on the rest of the farm with the approval of these two splits. We also have his attorney working on a joint driveway access agreement, which will be in place before the sale of either property. Right now, the folks who live in the existing farm home want to stay there, but they would like to build new. And he already has a young lady that he works with training horses that wants to buy the existing home. So that's kind of what he's looking for.
Thank you. Anyone else wishing to speak in support? Anyone wishing to speak in opposition? Roger?
The Town of Deerfield has approved this petition, conditioned upon a deed notice regarding no further development on the balance of the A1 exclusive zone land. Also, they would like a shared driveway easement agreement.
There's a waiver request further down the agenda. Class.
Yes. Second item under E. You want it?
You should take care of that before.
You want to go ahead and?
Move that?
Well, we should hear from you.
Yeah, I can set it up if you want. The applicant is asking for a waiver from the minimum frontage of the 66 feet of public road frontage. This would be for Lot 2. The surveyor is showing a 20-foot wide access easement on the proposed certified survey map utilizing the existing driveway. So the access easement will serve both lots as well as the residents to the north, which is zone A1 exclusive. And then there is an email from the agent explaining the hardship as well within your packet.
This is family, correct?
No, this is not family.
So the family.
No.
Yeah, can you read the email? I don't.
It's the third page on
Oh,
the second.
Should be in there.
You have to go, that's the zoning, you do it on to the whatever, under section.
Oh, got it.
Do you have it?
Yeah, I
Our
can read. Yeah, I can go
computers
through
are-
it. Yep. Yeah. So Jim Lowry is just basically explaining the situation. The front lot consisting of the existing home is fine. The back lot is where the hardship comes in. There is a barn that will stay with the remaining acreage, so there isn't a good way to establish that 66-foot touch, the flag part of the lot. The new 1.2 acre lot, McCauley lives in the home in the back of the property. He's already got people in mind that would be purchasing both sites. The family that currently lives in the original farm would like to build new and stay on the farm. The original home would then be purchased by a young lady that Mr. Cowhey, am I saying that right?
McCackey.
Okay, has been teaching how to train horses. So,
Well, which parcel would be sold?
Both properties within the red outline. So the existing farm home and then the new buildable site.
But you mentioned two parties, though. One would be farming still.
yeah, so you've got the issue with a landowner to the north, which is on the A1 exclusive zone parcel. And I believe Jim is referencing the barn that's situated north-south, runs parallel to Highway 73, correct?
Correct.
So that's the barn that I mentioned earlier.
So the property to the north of these two proposed lots is different owner, under different ownership, including that corner green space up there.
So everything around the red outlined area is owned by everything right now is owned by Mr. McCackey. He owns all of that, and he's trying to separate the
All of it
original
being-
farm home, which is out next to the highway.
So all of it being within, well, in our diagram here, it shows there's a yellow line. I guess it'd be the black outline parallel to 73, and then east-west. Well, it looks like a wooded line, wood line there,
Yep,
tree line, I should say.
yep. That's all part of Mr. McCackey's property.
Okay. So, question then I have for Dan or the petitioner would be, why create a landlocked, a lot without road frontage when there's property to the northeast right along 73 that would have
Well,
road frontage?
the main reason for the hardship would be the fact that to the north of the barn is the horse pasture and the training area. So if you bring a driveway in through there, now you've created a mess for them to try and fence it to train or to pasture the horses. Because right now the horses go back in to the north of that south hedge line, so to speak. That is their pasture area.
Okay. You said to the north of the hedges?
To the north of that east-west hedge line on the south.
Mm-hmm.
One of the significant issues with this property is that it fronts on Highway 73. It comes right out of the village of Deerfield. The access to that roadway is very limited. They do not want to have additional curb cuts on Highway 73. So the only access for this area is going to be the existing driveway.
Okay. Well, you've stated something that's different than what's on the application as far as hardship.
I'm sorry, I thought I put that on that application that it was a controlled access highway. I apologize if that isn't in there.
It is in the email, I'm
Yeah,
sorry.
yeah,
but it's
I
not-
read it, yeah.
Okay.
It's not in the application. Okay, thank you. Those were the questions.
Supervisor Patel?
Stepping back from the legal requirements and what constitutes a hardship, I'd like to look at the broader issue of whether this is an orderly development of the land, which is part of what we talked about when we discussed an ordinance amendment to address these situations. And I actually like this proposal because the alternative in normal times would have been a flag lot. So the back lot that has that nice rectangle to it would have had a flag coming out to 73 to create a touch. And I just think it's more sensible to have kind of rectangular lots of regular shape when we can. And so here, you kind of have the agricultural lands surrounding the residential lands, and then the two relatively rectangular pieces, with the exception of that little jog. It lays out nicely, so I think it's a relatively orderly development of land. So notwithstanding the issues regarding need to justify the variance, I kind of like the outcome.
The other issue too is, when I first looked at this, was the possibility of utilizing our requirements for the shared access, the 66-foot wide access easement that we require. And I don't believe there's going to be enough room where the existing driveway is. And then also our requirements state that our shared access provisions can only serve residential lots. And you've got the parcel to the north, which is only A1 exclusive, so that kind of eliminates that. So.
Thanks. That's a nice vision.
Is that a motion to approve the waiver?
Oh, had we not?
No, we don't have any action.
I'll approve the waiver.
I'll second it.
Okay, any further discussion on approval of the waiver? Seeing none, all those in favor say aye.
Aye.
And so the waiver is approved. So to go back up to rezone 11,081.
I move approval
With conditions.
with conditions.
And I'll second that.
Okay. Any further discussion on the rezone with conditions? Seeing none, all those in favor say aye.
Aye.
And it is approved.
Thank you.
You're welcome, thank you. Okay, I don't have any more forms. If you've got 11,082.
I do not have that one.
Is anyone here from the Varley Family LLC, Town of Verona?
Barnes Corporation. Anyone here from Barnes Corporation?
No, that's later.
1182.
Oh,
It says Varley.
Barley.
yes, that's the Barnes
Okay,
Corporation.
all right.
Oh, yeah, sorry.
I'll move the table.
Second.
All in favor of tabling due to no petitioner?
Aye.
Aye. Okay. Did you have questions? Okay. Next is CUP 2362, Madison Crushing and Excavation. It's going to snow, but we don't need to evacuate yet. Okay.
Please don't evacuate yet. Good evening. Paul Johnson on behalf of Madison Crushing and Excavating, and also John Belkin is here next to me. We are here tonight to basically ask for renewal of two conditional use permits for the quarry that Madison Crushing and Excavating currently operates on 5185 Rhino Road in the town of Burke. The existing quarry consists of three parts, what we call a center part that has been in existence for many years, and then a northern area and a southern area. Each of the three areas is serviced by a separate driveway. I believe the original application that was submitted for this process requested a separate conditional use permit for the north and the south areas. I believe that has now been combined into one conditional use permit to cover the entire parcel, of which Madison Crushing does not object to that procedural change. We have reviewed the staff report, and we have reviewed all of the conditions that the staff is recommending and have no objection to any of those at this point.
Okay, anything else?
Not at this time.
Okay. So I have three. So anyone else wishing to speak in support? So what did I got Paul Johnson, John Belkin, and Bill Ziegler.
Bill is sitting behind, but I think he chooses not to speak at this point.
Okay, thank you. Okay, so again, anyone else wishing to speak in support? Okay, so to speak in opposition, Emma Godfrey.
Okay. I ask the petitioners to let the.
Yeah, if you would.
Do you need us to vacate, evacuate?
I'm Emma Godfrey, and I live at 3410 Sandy Lee Lane in Madison, in the town of Burke. We bought our property in 1979 from Harold Ziegler. The quarry was not in operation at that time. Harold told us that it would be completely closed and made into a park. Shortly after we built our house in 1980, they started proceeding to use the quarry again. Madison Crushing and Excavating has let their CPU run out now twice. The first time, they were rewarded with a CUP with more land, so that they got more in there. In other words, they were rewarded for not being compliant to their CUP. Mr. Ziegler's oversight is both irrelevant and incredible. It's irrelevant because the law does not reward illegal acts, even if the acts are negligent and rather or intentional. He was rewarded more land to the quarry for his first offense. Now, if the CUP is okayed, he will be again rewarded more land for his offense. It pays for him to leave the CUP run out because he always gets rewarded. The neighbors filed a lawsuit against Madison Crushing and Excavating, and on April 7th, 1989, Judge Robert Pukowski made an appointment to come out to inspect the quarry on the neighboring houses. This group consisted of Judge Robert Pukowski, 2 people from the Dane County Zoning Committee, 2 people from the town of Burke, Bill Ziegler and his attorney. The neighbors were not allowed to inspect the quarry. At 1:30, they met, the neighbors, at 1:30, the whole group met with the neighbors, and they all walked through all of our houses. The judge said nothing when he was touring the houses. Then we all walked down to the end of Sandy Lee Lane. The judge stood on the middle of Sandy Lee Lane and spoke for the first time. Judge Robert Pukowski said, "This quarry shall not go further than the middle of Sandy Lee Lane. It will be too close to the houses on the corner of Burke." One person from Dane County Zoning was writing everything down, and so was Stephanie Jensen from our town of Burke. Now, one of them had put in that CPU 1159, the quarry will not go further than the middle of Sandy Lee Lane. Then that was not abided by. When the neighbors saw that they were going further than what the judge had stated, and it was in CPU 1159, some of the neighbors called Dane County. They said they were following Burke's map. We should take it up with the town of Burke. Burke told us they didn't have time to redraw the map, so he got more than what further down from Sandy Lee Lane. Neither Dane County nor the town of Burke would work to enforce the CPU 59. Neither would enforce the fact that Madison Crushing and Excavating was violating CUP 1159. They went farther than the middle of Sandy Lee Lane. But if we wanted to solve it, we could go to court and have it enforced. We couldn't afford another lawsuit. We went to every meeting on the quarry, both in Burke and on Dane County. I have notices on these meetings. Both say renewal of the conditional use permit when it's been applied. The Burke Plan Commission said, we don't need to discuss this because it's only a renewal, not a new CUP. So when I was at the town, it was never discussed. Renewal to me means the previous conditions should stay the same. I think either the town of Burke or Dane County didn't transfer this condition on the last CUP because they didn't want to enforce the condition.
You just have a few seconds left.
Now, I want to say that neither worked to enforce the condition, and this is why neighbors and I don't think he should be awarded the 9.5 acres that he's asking for to the north of what they already have.
Thank you, Ms. Godfrey. Next, speaking in opposition, Gail Zimmerman.
Gail Zimmerman, 3409 Sandy Lee Lane, Madison. Live right across the street. I'm probably just going to repeat a little bit that Emma said, but we purchased our land in 1977. And we were told at that time the same thing. That pit was, the grandfather pit was dead. Never will be used again. They had an old crusher out there for sale. And we were told, that's it. It's always going to be farmland, not expanded. Well, it is. And as far as going past Sandy Lee Lane, the same thing. They're past that. It's repetitive of what she said in a way. But I'm not in favor of any of the expansion, nor the 20-year deal that they're trying to put on it. If it does get expanded, or on the CPU at all, 20 years. So that would be about it. And the noise and the dust is bad.
Thank you.
Okay.
Next, wishing to speak in opposition, Bridget Harlow.
My husband and I bought an acre parcel of land in 2007 on Sandy Lee Lane, and then we built a new home there in 2008. When we purchased the land, we were not told anything of a blasting or excavating quarry across the street. We were only given paperwork regarding the annexation of the town of Burke into the city of Madison within 20 years of that date, which was perfectly fine with us. The house we have and the land that I own will be the legacy that I give to my grandchildren and my children someday. I do not want it to be devalued in any way. We have installed geothermal and solar panels through the Madison Group Buy on our home to increase its value. So you can imagine my surprise when the first blast shook through my house, knocking pictures off the wall, causing cracks in my basement foundation and window casements, scaring my animals and causing general upset between me and my family members when we thought perhaps an explosion or a bomb had gone off somewhere nearby. When I was able to speak with my neighbor about it, she said that it was blasting from the Zieglers and I should be receiving notices. I have never once received a notice. I have stopped by the Burke Town Hall twice since I moved in and asked to be put on the list. They have never responded. Last fall, when I learned that the CUP was expired and up for renewal and that they wanted to expand the area all the way to Burke Road, I went to the office of Bill Ziegler and spoke to him personally, and among my questions was asking to be on the list of those who received blasting notice. I can constantly hear the beeping of trucks backing up, the traffic noises of the trucks on the road, not to mention the gravel and the other rock that falls from the trucks onto the road, and the destruction of the roads having constantly battered them, and the endless lines of traffic backed up behind them with the evening people commuting home. It is my understanding that when they work closer to the surface, which they will if given permission to have this 9.5 acre expansion, that there will be a great deal of dust, additional noise, and more trucks exiting and entering an additional north gate that is beyond the Sandy Lee Lane marker. I was at the Town of Burke Planning Commission meeting on January 11th when they discussed the renewal of the CUP with Mr. Ziegler and his attorney, but we were not allowed to speak. Thankfully, my neighbor Julie Bockenkeller had a list of pertinent questions and concerns compiled for the members to ask on our behalf. Many of the valid concerns were met with, "I don't know," or "We don't have any data or studies regarding that," and "We've always been here and we've always done it this way." I've always worked in churches for the past 35 years, and I've heard the phrase, "We've always done it this way," enough times to know that that means it is time for a change. And change is happening all around us. At the same time my house was constructed, Little Explorers Daycare went up next door to me and has currently over 150 children, ages infant to kindergarten, enrolled there. Their operating hours are from 7 a.m. to 6 p.m. during the week and have a lot of drop-off and pickup traffic coming through. They also have animals, 2 horses, 4 sheep, and at least 3 llamas. Gail Zimmerman, who was just here, has 2 horses. Additional changes, a housing development just east of us called the Burke Conservancy, where there are hundreds of homes there priced from $90,000 to $450,000. Brand new Viridian homes, which I see on there, are going up just off of Felland Road on the other side there. Not even 2 miles to the north of the quarry is a major shopping center that has expanded. Cabela's, Costco, Marcus Palace Theaters, Prairie Lakes Shopping, Woodman's, Target, and soon to be a huge Menards. With all this expansion, more residential is sure to follow. Madison Crushing and Excavating has stated that the Bricktown Planning Commission meeting that they do not have any major contracts pending with Highways or Department of Transportation. They do not believe that they are in jeopardy of losing business as a result of being denied the 20-year CUP extension, especially since they have a large non-conforming area, that center area, which we spoke of earlier. They are a multi-million-dollar business that has continued operations not once, but twice under an expired CUP, not following the restrictions. May I just add, in light of the future annexation of the town of Burke residents into the cities of Madison, DeForest, and Sun Prairie within the next 20 years, and also the future growth of the commercial and residential development, the Madison CUP crushing and excavation be denied for our residential and environmental growth for our families and our neighbors' future legacies. Thank you.
Next, wishing to speak in opposition, or you were just registering, Kim?
No, I just registered.
Okay, registering in opposition, thank you. And wishing to speak, Kim McCain?
Very short, but I wanted to let you know something that's very, very important to me. I've been asthmatic since I was 2 years old, and I've had to work with that all this time in the last couple of years, last year or so. It's gotten a lot worse because we have, behind us, we have those other buildings going up, and then we have these, if those expand, that sends a lot of stuff into the air, and then that gets into my lungs. And I used to be able to do once a week, use a puff with it, but now it's twice a day. And it's kind of expensive. I mean, I'm not asking anyone to pay, but hey, you can, volunteer. But that is a big concern. The other thing is I was sitting, we have a pocket door to the powder room, and I found that it has tilted. And because I went to close it, so one of the girls couldn't get in, my cats, and I realized it couldn't close at the bottom. And now normally, fortunately, none of them got really scared like we've heard earlier today. None of them, they heard the boom. I get unnerved more than they do. So right now, it's really, really kind of loud around there. And with someone with sensitive ears, this is difficult, but it's the asthma that's the big problem with me. And I'd like that considered in that fashion.
Thank you.
That's it.
Okay, thank you very much. Anyone else wishing to speak in opposition to CUP 2362? Yes, and did you have a chance to fill out a form? I did.
You don't have to run.
I'll get up here before,
We'll wait
so in
here.
case my paper gets lost.
No.
Well, why don't you tell us your name and
Yes,
then
please.
Julie Backenkeller, 3400 Sandy Lee Lane. We purchased our property in June of 2013. Neither our realtor nor the property owner informed us or gave us any information about the quarry. We knew it was there just from seeing the operation, but our formal introduction came with a blast notice and the shaking of our home, which was quite a shock. I understand the need for aggregate and that the Ziegler's is a family-owned business with employees. However, the county either need to choose between the quarry or residential development, because this is, to me, kind of a planning nightmare. the two don't mix. Similar to a city person moving next to a farm and then complaining about the smell, I get this. We just moved out there and they were there first. However, look at to the bottom, all the development that's going. And as Bridget said, there's way more people out there than there used to be. There are areas in the existing mine that have not been exhausted. Why are they not mining the materials out of those areas? Why are they asking to disrupt neighbors to the north and the Burke Station Cemetery, which I believe is protected under Wisconsin Statute 157.70? The 9.5 acres in the most northern part of the CUP are right up against 3 houses and 63 people in the ground. And I don't understand why, if they're trying to be a good neighbor, why would they want to disrupt these people's lives when they have plenty of other places that they can mine? The northern CUP 1642 is set for reclamation on 2/14. The town of Burke has not yet met about this. There's no town action plan. They've not heard testimony from any of us. And as someone stated at the Town Planning Commission, residents were not allowed to comment or ask questions. Yet we listened for 2 hours to testimony from Mr. Ziegler and his attorney. The whole thing seems backwards to me, that this should be a back and forth thing, not, so I appreciate you listening to us tonight. Without the town action plan, this cup will not be approved tonight, but I would like to bring some thoughts to mind if you're looking to approve something like that. Because of the growing population and residential development in the area, limit the cup to 5 years. A lot can change in 5 years, and we want to be sure the quarry is a good neighbor to everyone. Offer pre-blast surveys to property owner, property assessments, inspections to homeowners within a blast zone area. Why should we lose money because of damage done to our property so that they can profit? Well water checks and filtration systems to neighbors within a certain distance. Emma has had to change her filter on her water system every time they blast, and we just don't drink our well water after we've had it tested a couple of times. Dust control, monitoring. There has to be something to address air quality for neighbors, including the up to 200 kids at the daycare that he's got the ability to have that want to play outside during the day. Blast notices to everyone within a half a mile of the quarry, since the town clerk noted that she can feel the blast, and that's about a half a mile. The distance needs to be increased. Limiting the hours, requiring squawk boxes on trucks. The noise of the quarry is ridiculous, blasting, crushing, traffic, and the beep, beep, beep that is like the Chinese water torture and drives you berserk. Require paved roads, not simply crushed blacktop. Require submission of seismic records from blasting to both the town and the county. Limit the cup area to the south of Sandy Lee Lane, as ordered by the judge in 1994. South of Sandy Lee Lane, not to the north. Require transportation study. Reiner Road is crazy busy with vehicle traffic, and the trucks are just going to make it worse. Address protection of the cemetery. 63 people are buried there, and blasting right up next to it, to me, is just disrespectful. I understand that you need to balance the needs of the mine with the rights of the neighbors, but again, the southern area hasn't been utilized at all. So why do they need this huge CUP? I don't understand. Why does it have to be for 20 years? When Madison Crushing has not proved themselves to be good neighbors in the past or to file necessary documents when required, I don't believe that their cup should be approved for more than 5 years. And you can't tell me that the expansion of this quarry and a 20-year cup will not affect my property values. You can't tell me that the noise from the blasting, crushing, and truck traffic is not going to affect our ability to enjoy our properties. You can't tell me that the dust created by this operation is not going to affect our ability to be outside, keep our windows open, and work in my garden. And again, the balance has turned that there are more neighbors now than there are just the quarry. It's not just a few houses out there anymore. And this is a zoning issue. I don't believe that there should be this quarry around all of this residential development. And I'm asking you to deny and to let the CUP that is expired, 1993, to be reclaimed.
Thank you, Ms. Beckencover.
Thank you.
Anyone else wishing to speak in opposition? Okay, Mr. Ziegler, you have 3 minutes to rebuttal.
I'll be very brief. The people who speak in opposition, they make valid points. However, the Madison Crushing and Excavating has been a good neighbor while it has been in existence. If the CUPs for the property have been allowed to expire from time to time, as is currently the case, operations have shut down in the CUP area. This is not an example of a rogue mine where Mr. Ziegler and his family are trying to do something inappropriate. They made a mistake. The permits have expired. They are here now seeking to renew the permits and to expand the area. They are seeking to expand the area so they can make money. They're in the process of trying to make money for their business. That is what they are supposed to be doing. We realize that this quarry is located in an area that is changing its use over time. For people who have bought their houses recently to tell you that they didn't have any idea of the workings of this quarry when they bought their property, that simply is beyond belief. This is an operation that is pretty much hard to miss. If the people speaking in opposition are complaining about truck traffic, the traffic on Reiner Road is very heavy at all hours of the day. It is not the fault of Madison Crushing. They are asking to continue doing business as they have been for the last 30 years on this property. They are not looking to expand their business, just expand their ability to do business. And they have followed all of the terms and conditions of the past CUPs, and they are willing to do so going forward into the future. The reason that they are asking for a 20-year permit is because by the way that this CUP is being configured now, basically Madison Crushing is losing its grandfathered in area and is basically going to fall into the whole thing. So next time this comes around for permit review 20 years from now, it'll be a different game. So they're asking to have 20 years right now so they can conduct business as they have been for the last 30 or 40 years, knowing full well that if they violate the terms and conditions of the conditional use permit, there are appropriate remedies. They've got to be almost done.
Yeah.
Thank you.
You're welcome, thank you. Okay, Roger?
The town of Burke has not taken action on this petition.
I'll move postponement due to public opposition and lack of town action.
I'll second.
Okay, so we do have the motion to postpone, but we had discussions. Go ahead, please.
Madam Chair, did I miss my chance to ask questions?
Go ahead and ask questions, please.
Oh, actually, I was going to
Because
ask.
it's a public meeting, so this is our opportunity to ask questions.
Well, actually, I'll ask the petitioner and then an opponent or two. Just to the petitioner, you made a reference to Madison Crushing in its period of existence. Was this quarry under a different operator at an earlier time?
No, to my knowledge.
I believe it's been in existence.
I just took something that.
Existence of Madison Crushing.
It opened in the 30s under a WPA program.
Oh.
Madison Crushing didn't have anything to do with it until sometime in the 60s.
But for the modern period that we've been hearing discussed, it was all
Before my time.
Okay. Because I just took something that was said to be, seemed to imply that there had been anyway, the way I read it, it sounded like Madison Crushing has been a good neighbor, but maybe a previous operator may have been what people were. Anyway, never mind. You've answered the question. Thanks.
Could I just ask one question, too? Dan Everson's here, and he came out this summer to see if we were operating in the wrong areas. And I guess I visited with Dan at that time. And Dan, did you see any place that we were operating outside of the non-conforming grandfathered area?
Nope.
Okay, thank you. Other questions by Supervisor?
If you're going to ask opposition
Oh,
before
yeah.
they leave the table. So we have these two areas that are expired. Has any reclamation of, well, first of all, of those expired areas, is any of that, is the material exhausted from any section of
The stuff on the southern end is sand, the stuff on the northern end is limestone. They're two completely different products. The stuff to the north that's under the current CUPs that we've had, it has been mined out. And we can expand to the north and still get limestone. The stuff in the south is sandstone, and it's not for, Dan or Todd would know what the difference is between sand and limestone as far as selling it for road products.
Well, regardless of the type of material, my question was whatever material was being excavated is in any portion of this whole area, is any portion of it exhausted? In other words, is there any area that is ready for reclamation?
There's areas that we started reclamation in the grandfathered area, and there's areas that we were using because it's part of the grandfathered place that we couldn't have started to reclaim because we still need to access it because of the grandfathered protection of it.
And if the CUP were to be granted, in what areas of the site would blasting continue?
Well, the stone still is in existence in that 9.5 acres up there. That's where we would be going.
That would be, okay, so no other part of the site.
The grandfathered area.
And
which is
in that
non-conforming.
9.5 acres, do you have an estimate as to the volume of material and over the amount of time that you would be excavating and taking the material?
10 to 15 years, and then there's another year. They gave you, I believe, 2 years beyond the permit to do reclamation. 1 year. So it's going to be in the 15 to 20 years of material up there to get our work done.
Quick question for staff. So this isn't a subdivision, so it doesn't require any approvals from the City of Madison, but has the City of Madison been offered any opportunity for input on this, given that this will come?
They've received all the zoning and land regulation packet, all the notices, and they have yet to respond.
All right, thanks.
Questions for the petitioner?
Yes. Now that you've heard at least one complaint about the beavers, are there any plans to install squat boxes on vehicles?
The squat boxes that were put into the permit conditions are for equipment that we own that are on site.
Mm-hmm.
They're not on the City of Madison dump trucks that come in, or the City of Madison Water Department, or the Dane County trucks that come in. Those aren't in our control.
I understand.
Other questions for the petitioner? Okay, thank you. We have some questions for those who spoke in opposition.
Right. So I guess we're going to talk to the opposition now. I was going to ask, I think it was the last speaker or another, basically the question was to clarify.
Julie, I think you were the last speaker. Julie, were you the last speaker?
Either one of you, I think it was the same. Why don't both of you come up? And it's a pretty straightforward question. You know. I think you'll know the answer. So the question was, I thought I heard you say that the town of Burke denied public testimony. Could you clarify what was the rationale? Or
At the Planning Commission meeting, I had requested, well, a week before the Planning Commission meeting, there was nothing listed on the town's website about the meeting. I called and specifically asked when they were going to be discussing it. And the town clerk told me she didn't have time to put it on the calendar. So I contacted all of the neighbors to tell them that this meeting was going to happen, and I requested a list of the Planning Commission employees from her, because that also is not on the website, so it's a mystery. And asked them if they would allow for public comment or questions before they made their decision to recommend or deny the CUP, and they refused. The town clerk refused to send an email. You know, I asked her specifically to separately send an email from the town clerk requesting for time for public comment, and she refused. And then at the beginning of the planning commission meeting, the planning chair read a little statement that they would not be taking public comment. But so we sat there for 2 hours and listened to a lot of pen clicking and talking about beepers and things like that, when there was so many other questions that we all wanted to ask and comments that we wanted to make. And we really felt as if it was a one-way street. And after the meeting adjourned, I made a statement to the planning commission chair that I thought it was really unfair they didn't let us comment, and he stated that, well, look at how many people were here. If I gave you all 3 minutes, we would have been here all night. And Emma had tried to talk to Mr. Ziegler, and he brushed her off, and out the door he went and wouldn't answer any questions or discuss anything with neighbors. So we all felt pretty slighted after the planning commission meeting.
Okay, thanks. That's what I was asking.
Just curious, is anyone from the town of Burke here?
Just a quick follow-up to that. You mentioned that the planning commission, was there a subsequent meeting at the town board?
No, the town board meets on February 15th. But the other thing that I requested for the town clerk as well was to put this meeting on the town's calendar so that people could see what was going on, and she refused that as well, stating that she didn't put Dane County meetings on the town board. And I said, it's the only thing that this is dealing with is the town. So to me, it's like, you know, what they don't know won't hurt them kind of thing. And I just feel that more information is better, more conversation is better, not one-sided. So, thank you.
Any other questions? Thank you.
I think I did.
Yeah, and then you had questions.
Yeah.
Correct. Okay.
Yeah.
So on the plan.
Yeah, if I could, no, I'm done with questions, but I would have discussion if there's discussion.
Go with discussion. On postponement.
Right. Okay. Well, just that, with a recent quarry, we lost a lawsuit in part because the process was found faulty, and we, the Zoning and Land Regulation Committee, were held by the judge as liable for the flaws in the town's proceedings, since our decisions are based on the foundation of the town's actions. So I'd say that right now, apart from any substantive issues relating to the quarry, which there seem to be some, and obviously we're not voting tonight to approve or deny the CUP, but if we have to clean up the process at the town level, and not just here,
right,
before we can take action on this.
Thank you.
So it may be something that needs to be communicated to the town when the board has their meeting, that there is ample opportunity for their residents to address the issue.
Go ahead.
When I first heard of that, I talked with the town clerk. They said they hold their public hearings at the town board level. And that is going to be occurring in February. So I'll keep the committee apprised of that, and I'll also send a letter to the town chair with regards to holding public hearing and open meeting laws.
Thank you.
Does everyone understand what Roger just indicated? So you'll want to make sure, if you want to follow up on this, to go to your February town board meeting, the very first one. So, or at least check the agendas so that you won't
Yeah, I
miss it.
just checked and there's nothing on the website about it.
Okay. Well, keep bugging the town clerk then.
Okay. No further discussion, comment? Okay. Then on the postponement, all in favor, say aye.
Aye.
And it's postponed. Thank you. Next is CUP 2370. It's Blooming Grove Fire Department and Dane County. Tracy Harold.
Hi.
We'll just give it around. Yeah. So we can hear you. Good night. Okay, Tracy.
That's it.
Just introduce yourself.
I think so. Go ahead, Tracy.
Okay. My name is Tracy Harold, and I'm the Director of the Dane County Library Service. We're currently housed at the Job Center at 1819 Aberg Avenue. And what is before you is the conditional use permit for our operation to move to what was the fire department at 1880. It may have a different address now, on Stoughton Road, where the Blooming Grove Fire Department used to be. And our operation is mainly, we do have books. We've got a collection of about 50,000 items that would need to be housed at this site, as well as 2 vehicles, a smaller box truck, which we call the Readmobile, and then a large bookmobile, which is a 35-foot vehicle that houses about 4,500 library items. We have a staff of 10. Most of those folks are part-time, so staff is in and out a little bit. So we do have the need for some office space and for some work area, as well as we would get UPS deliveries for library materials that we've ordered and are receiving and processing. The bookmobile goes out daily, Monday through Saturday. And so Monday through Thursday, it leaves early afternoon and gets back about 8:30 at night. Friday and Saturday, it leaves about 9 or 10 in the morning and gets back late afternoon. Other than that, there are 4 bays there. We would occupy the 2 closest to the administrative and housing area that was for the firefighters. And the Department of Emergency Management would have the other 2 bays for their CV1 vehicle and some other emergency vehicle. And I think they go out when they're needed. So there is no regular schedule there. I think that's pretty much everything. The Readmobile, it goes out more sporadically because it visits daycares for play literacy sites, so it doesn't go out as often as the bookmobile, several times a month. So yeah, I think that's just about everything.
Okay, thank you, Tracy. Anyone else wishing to speak in support? Yes, Todd.
Certainly speaking in support. I just wanted the committee to know that the town, when the town took it up, the town of Blooming Grove, both at their plan commission and town board meeting, Tracy, as well as Hans Hilbert of our office, and I were in attendance to support the petition. And just a little perspective, the town was very supportive of the proposal. They thought it was a very compatible use with what's there now. In fact, likely a less volatile use than dispatching, say, fire trucks. So the very little traffic would be going in and out. The vehicles would be coming in, would be there in the morning and then exit and then come back at the end of the day. So very little trip generation beyond the employees going to work and leaving. So just wanted the committee to be aware of the town's support, that as a county agency we're also supporting the library services efforts here.
Great, thank you. Anyone else wishing to speak in support? Anyone wishing to speak in opposition? Roger.
The town of Blooming Grove has approved this petition with no conditions. Staff is suggesting 3 conditions be placed on this conditional use permit.
Move approval with the 3 conditions.
Second.
So we have a motion to approve with the 3 conditions and a second. Any further discussion? Yes.
Todd, could you remind me, what's the timeline on the town being dissolved, and did they already dissolve their fire department? And are the library trucks going to have sirens?
Yeah. I'll let Tracy answer that question. I don't know what the timeline is for Blooming Grove's.
I know you had that handy chart, so we can just look up the chart.
Is it 2022?
23, I thought. Somewhere in there.
It's in the near-term horizon, but
So that's pretty quick.
It's not immediate, but it's.
And did their fire department merge with another?
I don't know who's, they may be under contract services with the city of Madison to provide fire service, but I'd have to verify that.
I think that's right. I knew I heard the answer to that question, so that sounds like what I heard.
If you'd like for us to follow up and check on
No.
it, we can, but I
No,
can't say that for certain.
It was more a refresh my memory thing. Thanks.
Any further discussion? All in favor, say aye.
Aye.
And it's approved. Thank you for coming. Okay, next is ordinance amendment 41, amending chapter 82 of the Dane County ordinances incorporating the town of Dane comprehensive plan to the Dane County comprehensive plan. And here available for information is Richard Haig from the Township of Dane. Thank you. Would you like to speak?
I don't have to. It depends what shakes down.
Okay, thank you.
Okay.
Roger, do you want
Kurt.
to? Kurt, I'm sorry.
Yeah.
Go ahead.
The town of Dane has had a comprehensive plan on the books with the highway toll plans since 2002. This amendment is going to add a transfer of development rights program to that plan. The need arose with a specific petition, but it's a generally, it's not an overly complicated TDR program. There's no ratios involved or increase of density. It's just they're wanting to be able to move some of the housing potential to places that are less likely to be, open farmland and things like that. Okay.
Questions? Did you have any questions? No. Okay, good.
I'd move approval.
Okay, we have a motion and a second to approve. Any further discussion? Seeing none, all those in favor say aye.
Aye. Aye.
And it is approved.
Thank you.
Okay, next is ordinance amendment 66, amending chapter 17 of the Dane County Code of Ordinances, updating official floodplain maps to reflect letter of map revisions. Roger.
In order to stay in compliance with the requirements of the FEMA floodplain program, the county is required to adopt floodplain regulations whenever there is changes. There have been 3 changes over the last year. First one is to the east branch to Starkweather Creek that is located in the city of Madison and a portion in the town of Blooming Grove. The change was to allow a culvert located near Milwaukee Street in the city of Madison, so they just replaced it, and it affected the floodplain minorly. The second revision was to the Upper Badger Mill Creek. New stormwater detention basin was installed on sections 12 and 13 in the town of Verona. If you go down 12 and 18, if you look to the north and to the south, those major detention areas, they were constructed and the floodplain elevations were needed to be changed due to that being part of a floodplain. The third one is Badger Mill Creek. There's a new box culvert for a new road under Hubble Road in the city of Verona. That is one of the roads that leads to Epic. And that because of that box culvert, the changes are changed the floodplain elevation slightly in sections 8 and 9 of the town of Verona.
I move approval.
Second.
Okay, we have a motion to approve and a second. Any further discussion? Seeing none, all those in favor say aye.
Aye.
And the floodplain revision is approved. Next is ordinance amendment 67, amending chapter 10 of the Dane County Code of Ordinances regarding conditional use permits. And available for information only, we have supervisors from the town of Deerfield. Registered is Dennis Mant, Bill Rolfs, and Dan Kelly, and I see Mr. Behringer is here also.
Registering.
Nobody, they just registered available for information. But thank you, gentlemen, for being here. Do you want to?
Oh, yeah, I'm sorry. We started, so I believe it was back in 2012 that we started to allow, or possibly 2009, that we started to allow towns to join in with the conditional use permit process. With that significant change, there was also a change on how to appeal decisions. Because it was in the past they had some language in there about mineral extraction operations going, if they were to be conditional use permits were to be appealed, it would go to the county board. That was pulled over to affect all conditional use permits, whether approved or denied by either the town or the Zoning and Land Regulation Committee. With that being said, the process was quite clunky when we had people appealing conditional use permits, either being denied or approved. You may recall in the town of Dunn, there was Christie's Landing. In the town of Springdale, there was a motorcycle repair shop. There's also several others, but it was quite awkward to have 37 people review the facts of whether a conditional use permit was either approved or denied properly. A lot of feelings got in the way, and decisions were made or votes were cast with probably more on the feeling part than on the facts. So we looked at that. It was very awkward. Corporation Counsel was very concerned with the legal arguments made regarding this process. So Corporation Counsel has suggested that we change the ordinance. The suggested change was to just have all appeals go to the circuit court. Eventually they'll end up there if the appeal process continues. Dane County Towns Association had suggested that possibly there would be an intermediate step between the committee's decision and circuit court, and that would be the Board of Adjustment. Board of Adjustment is there to hear all appeals by any administrative decisions or committee decisions. It's already in place. And most counties in the state do use Board of Adjustment to, in that fashion, to appeal any conditional use permit decisions.
So what will Dane County do? What would Dane County do in the event of an appeal? Would it go to the Board of Adjustments?
That is correct. That is how the Dane County Towns Association has reviewed this ordinance amendment. The way it is drafted now, it does state that it will go to the Board of Adjustment, and their executive committee approved it. We've had 5 towns so far that voted to approve the ordinance amendment, and 1 has voted to deny it.
Okay, I'll move postponement because this actually starts the 30-day window for the chapter.
I'll second that.
Okay, we have a motion to start.
So towns have until what date to register their votes?
30 days after the public hearing, so this will be on the, I believe, February 28th meeting.
We have a second?
Yes, I did.
Okay. Any further discussion? All those in favor say aye.
Aye.
Okay, so the window starts. Thank you. Next is ordinance amendment 73, amending chapter 15 of the Dane County Code of Ordinances regarding proceedings of administrative agencies.
Should I?
Oh, yes, please.
Okay.
No one else is registered.
This ordinance amendment was introduced to the county board and referred to the Zoning and Land Regulation Committee. When it talks about agencies and subcommittees, there is a list of agencies, and there are not standing committees.
We don't have to do this. I emailed you.
Oh.
Yeah, because we're a standing committee. Isn't this the one where?
Yes, it is.
It was
One of the things is,
Yeah, but was it referred to all standing committees?
It's,
Just
if you've got
executive.
subcommittees that, anyway, this isn't, that's, I
Thanks for
have
coming
an
in.
it
email
was
from-
referred to the Zoning and Land Regulation Committee. This only applies to
Thank you, Jim.
agencies such as the airport, the Food Council. There's probably a list of 15 in that. They're not standing committees,
Right.
but this was referred to us for the Zoning and Land Regulation Committee to review and act upon.
I don't think we need to take any action. Our subcommittee is not the intent of the subcommittee cleaning up that this is.
That's correct. I believe they're with commissions like and other councils. There was a host of subcommittees being created that was kind of unmanageable. So they're reining that all in. As for the Zoning and Land Regulation Committee, the subcommittee to rewrite, it would not affect that subcommittee or any subcommittees of standing committees.
So this is informational.
It was referred.
Okay. Supervisor Tom, because you were on the committee also.
My concern of not taking action is that then we might hold it up. So
Okay.
my motion would be that this zoning land regulation committee's recommendation is no recommendation.
Second.
Okay, so we have a motion and a second to no recommendation.
But Todd has a question.
When we looked at it as staff today, we looked in chapter 15, and it does list the agencies that are referred to in ordinance, and one of them is our Board of Adjustment. So it seems like it would apply if the Board of Adjustment were to create a subcommittee that was advisory to the Board of Adjustment, then they would need to get the approval and support outlined here and put together a work plan for that subcommittee. So I think you're right, it doesn't seem to apply to our Chapter 10 rewrite subcommittee, to the zoning committee. But in our department, under the committee's purview, it looks like the Board of Adjustment seemed to be the only one that would be pertinent to our work. So, and again, I think it would be applicable only if the Board of Adjustment were to create a subcommittee.
Thank you. Anything else? Okay, all those in favor say aye.
Aye.
And no recommendation is approved. Okay. Items from previous meetings. Rezone 11,012, Town of Christiana. No one's here.
Okay. This petition was postponed at the July 26th Zoning and Land Regulation Committee due to no town action. The petitioner didn't file an application with the town. Since that time, he has filed, and the town has reviewed it and has approved it, conditioned upon the north property line to be shifted south to avoid the drainage ditch. They would like the drainage ditch to be on the agricultural land rather than the residential land. And this is basically the home site being separated off of the farmland.
I move approval with the conditions.
Second.
We have a motion to approve in a second. Further discussion? Supervisor Matano. All those in favor say aye.
Aye.
And it's approved. Thank you. The rezone 11,059, Bar Down in the town of Verona.
Yeah, this petition was postponed at the November 22nd meeting due to no town action. There is a minor revision to the deed restriction. The deed restriction stated that there would be 20 home sites at 2 acres. A few of those home sites fell short. The deed restriction is being revised to reflect the 1.9 acre and 1.6 acre parcels, but they're still only going to be limited to 20 houses, I believe.
All right, I'll move approval of the, to amend the deed restriction.
Second.
Okay, we have a motion to approve the amendment of the deed restriction. And no one's here.
Mr. Proctor was here, and I said I don't think it'd be necessary. It's a very minor provision. So there was representation.
So we have the motion and a second. Any further discussion? Seeing none, all those in favor say aye.
Aye.
That's approved. Thank you for waiting. Rachel Holloway for 2628. LP 28 and the preliminary plat in Spruce Valley. Go ahead.
Good evening. I'm here representing JSD Professional Services out of Verona. We're at 161 Horizon Drive. So we have tonight the preliminary plat. This was started last year with the town, and we went through a series of approvals there, including the preliminary plat, which was approved in July of 2016. It's for 10 lots, which is Mitch Sprecher is here. He owns the existing property and would have one residence and be creating 9 additional new lots. We have some new roads and road extensions planned as part of this. It was, as a condition of town approval, we had to secure roadway dedication for Fallen Oak Drive along the north side of the plat. And for that reason, we had several months of delay. During that time, Mitch and his attorney have worked with the neighbors on the lot just to the north to figure out how to get that right-of-way dedicated, since the town had never required that it be dedicated. It had simply been reserved. So now we have an agreement. We had a CSM submitted to the county, which has since been conditionally approved to get that right-of-way taken care of. So we'll plan to record that as soon as the town finishes the approval. So we're glad to report that that's working out. We'll get the right-of-way dedicated prior to the plat actually being recorded. We anticipate town approval on the plat and several related items on February 6th. So that's moving forward. And last night we just met with the town board. So we had a positive meeting with them there, and they indicated that they're going to approve it. I'll just add that we looked at the conditions of approval recommended for the ZLR committee and don't have any concerns there. If you have questions related to the roads or anything, we can address those tonight.
Thank you.
Would you like me to set this up a little bit?
Please.
Okay. So this is the Spruce Valley preliminary plat, which was accepted back on June 28th of 2016. This consists of 10 residential lots and 3 outlots, not quite 16 acres. The current zoning is A1, therefore there's no rezone petition involved in this one. In addition, there's no sensitive environmental features identified within this development. The lots will be served by private well and private on-site septic systems. Dane County Senior Planner Kirk Kodal has addressed the issue with Town of Middleton's comprehensive plan as well as the county's plan. And in his memo, he states that this meets the Middleton plan, maximum gross density of 1 dwelling unit per acre. This is identified on the Town of Middleton future land use map as residential, but is also in the intergovernmental agreement transition area. In addition, I've outlined some comments or conditions that need to be met. The public parkland appropriation requirement is to be satisfied. Private open space is shown for the purpose of public stormwater management and recreational trail easements. And then in lieu of dedication of the parkland, the developer is paying fees to the Town of Middleton to meet this requirement. All streets should be noted as dedicated to the public. Fallen Oak Drive, which is to the north of this plat, is being extended to the west and dedicated to the public to serve lots 9 and 10, as well as lot 1 of a proposed certified survey map, which is the last parcel to the west at the end of Fallen Oak Circle. So that's the certified survey map that Rachel had alluded to earlier. That certified survey map needs to be recorded prior to or at the same time that this plat gets recorded. Appropriate turnaround arrangements are to be shown on the plat at the east and west end of the Spruce Valley Drive. I believe they are addressed on the plat. Utility easements are to be provided. Street names. The Dane County surveyor approval is to be attained for Spruce Valley Drive. And then the other comments are just standard conditions with regards to the construction of the roads as well as the erosion control and stormwater requirements through the Dane County Land and Water Resources Office.
Rachel, everything still sound okay?
It does. I would just add a minor detail that there will be no trails as part of the development. The town did not require any, but otherwise, as you outline in here, we will, the developer will be paying fees for the parkland dedication.
All right. Do we have to wait for town approval on this?
Nope.
And then I'll move approval with the conditions listed.
Second.
Okay, we have a motion and a second to approve. Further discussion? Seeing none, all those in favor say aye.
Aye.
It's approved. Thank you.
Thank you very
Thank
much.
you.
Okay, we already took care of the Becky land waiver. We did all the ordinances. Seeing no other business.
Move adjournment.
We have motion to adjourn and a second. All those in favor say aye.
Aye.
We are adjourned.
Nothing like a good pet.